Why do juries trust a confident witness so fast? Because memory feels like a recording. In court, it is anything but. A witness can sound certain, detailed, honest. That does not mean the memory stayed intact from the street to the witness stand. According to Pace University's Hobb Law Advocacy blog, the core problem is simple. Accurate perception does not guarantee accurate recollection later. Researchers call this the misinformation effect. After an event, new details can slip in and quietly rewrite what a witness thinks they saw. Elizabeth Loftus helped make that danger famous. Even a changed word in a question can push people toward a different memory. That matters for trial lawyers. A careless interview can shape testimony before cross-examination ever begins. Lineups create another danger. Small signals from an officer can steer a witness without anyone meaning to do it. The National Institute of Justice has long recommended safeguards. Blind administration is one of them. Witness instructions should make clear that the suspect may or may not be present. And identification procedures should be documented carefully to reduce suggestion in lineups and photo arrays. The reform logic is straightforward. If the administrator does not know who the suspect is, the administrator cannot unintentionally cue the witness. NIJ guidance has emphasized exactly that point for years. Research supported by NIJ also found that double-blind lineups can reduce filler identifications. That means fewer known innocent people get picked just because they look closest to a witness's memory. The Innocence Project says eyewitness misidentification contributes to an overwhelming majority of wrongful convictions, later overturned by DNA testing. In its national data, 69% of the first 375 DNA exonerations involved eyewitness misidentification. That is why this issue belongs in every trial notebook. Memory is less like a video file and more like wet cement. Touch it at the wrong moment and the shape can change. So, the teachable skill is not outrage. It is disciplined witness handling. For prosecutors and defense lawyers alike, that means tighter questions, fewer assumptions, no accidental facts hidden inside the prompt. It also means attacking confidence carefully. Jurors often confuse certainty with accuracy, so cross-examination should separate the two with simple, controlled steps. One practical way is to walk the jury through estimator variables and system variables. Estimator variables include stress, distance, lighting, exposure time, and cross-racial identification limits. System variables include lineup design, instructions, feedback, and the way interviews are conducted. That distinction matters because some weaknesses belong to the event itself. Others were introduced by the justice system after the event. Confidence is especially tricky because it can grow after reinforcement. Post-identification feedback and repeated retelling can harden a witness's presentation, even when the original conditions were weak. Then comes New York's lesson. In 2024, the Court of Appeals issued a string of decisions pushing judges to scrutinize identification evidence more closely. In Vaughn, the court clarified the test for expert testimony on eyewitness identification. The question is whether the expert would aid the jury. Courts must not treat other evidence by itself as a reason to keep that expert out. In Mosley, the court tightened the rules for non-eyewitness video identifications. Lay opinion is proper only when the jury truly needs the witness's added familiarity to identify the person shown. In Williams, New York required a formal threshold hearing before certain first-time in-court identifications may come in. That matters when there was a prior police-arranged identification procedure. Courtroom identification can carry a special suggestive force. In Watkins, The court addressed the failure to request a cross-racial identification instruction. The message was clear. In eyewitness cases, lawyers should preserve that issue early and clearly. So, what should advocates practice? Start with witness prep and cross-design. Strip out leading assumptions. Test confidence against conditions, distance, stress, and prior suggestion. Published research and NIJ guidance point the same way. Memory needs protection, not blind faith. Next time you build a cross, ask one better question. What did this witness actually observe, and what was added later? Practice that skill with AI-powered courtroom drills at trialtutor.com. Like, subscribe, and share this with a lawyer.